It is his and his colleagues' generosity that has produced this lunch, and as I say, also supported the Society through the Patrons Program. And he is going to introduce both the discussion and our distinguished discussants, Judge Tomka and Professor Pellet. Paul, please.
Good afternoon, everyone. Thank you, Donald, for your introduction, and congratulations to you for completing a very productive term as president of the Society and for putting on such an outstanding conference. Who else but Donald Donovan could have commanded the cherry blossoms to open and the weather to warm up just in time for our annual meeting? It's a great privilege for my firm, Foley Hoag, to host this luncheon, and especially this informal conversation between two rock stars of international law, Judge Peter Tomka and Professor Allain Pellet. As president of the court, Judge Tomka has not only conducted proceedings with great dignity, efficiency, charm, and wit, he has been an innovator, bringing about positive change. Under his leadership, the court has adopted new and better procedures for hearing the testimony of witnesses, including experts, with special sessions devoted to witness testimony, ample time for examination and cross-examination by counsel, and questions from judges. Judges themselves have become more proactive in questioning both witnesses and counsel. The result is a court that is even more proficient in receiving and interpreting evidence. If you want to see how well this functions, you might go online and watch the videos of the oral hearings in Australia and Japan, and then read how effectively the court dealt with the technical and scientific evidence in its judgment. Ecuador-Colombia was an even more complicated case, with 4 expert scientists testifying for each side, plus lay witnesses, and the procedures, which were designed by the court last year for receiving this evidence, could serve as a model for other courts and tribunals. They haven't yet received the attention they deserve because the parties reached a settlement just before the oral hearings began. Judge Tomka has accomplished an enormous amount as president of the court, and we applaud his leadership. And in just a couple of minutes, we'll have a chance to observe his cross-examination skills. My friendship with the guest of honor, Allain Pellet, began exactly 30 years ago. In April 1984, Nicaragua filed its case against the United States in the ICJ. One of the great rewards I derived from participating in that case was the opportunity to work with Allain. It was his first big case in the court, too. As in Casablanca, it turned out to be the beginning of a beautiful Franco-American relationship. For 3 decades, we have been teammates in many cases. Of course, it helps to have a litigious client like Nicaragua, which has even more litigious neighbors in Costa Rica and Honduras. But working with Allain is always special. He is an outstanding teammate, always available to assist others by reviewing their pleadings and offering constructive advice, usually in the middle of the night, and he is receptive always to suggestions by colleagues. He has unlimited patience with younger lawyers. And he stands up to clients more firmly than any counsel I've ever known. He is unafraid to tell a client when he thinks the client is wrong and to say what the client needs to hear, even though it doesn't want to hear it. I can think of no one more deserving of the Manley Hudson Award. As an international lawyer, Allain is the complete package. He is a great scholar who has made enormous contributions to the law, as president of the ILC, as special rapporteur, as author of indispensable treatises. He combines these great intellectual attributes with unmatched skill as an oral advocate. He is the best I have ever seen. He is not just a great scholar. He is a great performer, an artist, a real showman, especially when you see him in costume, wearing his scarlet academic robe with the little epaulettes, bright white fur collar, collection of little medals on his chest, gesticulating to the court and mocking the other side with good-natured but biting humor. I know this from personal experience, having been the target of some of his rhetorical thrusts in cases when we were on different sides. Our generation, and we are the same age, our generation, which came of age in the 60s, was raised on rock and roll. In the world of rock stars, there was Elvis and there was everyone else. In the world of public international lawyers, especially now that our dear friend James Crawford is getting ready to ascend to a more sublime place, I mean on the bench alongside Judge Tomka, it's just the same. There is Allain Pellet, and there is everyone else. He is the Elvis of international law.
Allain, I have just a question. Why you have opted for this kind of interview? Usually, the recipient of a Hudson Medal deliver a lecture, and you have missed the opportunity to make a big statement.
Well, I think probably there are two main reasons. First, my illustrious predecessor, Bruno Sima, had this idea that an interview was more entertaining, and I think it worked well last year, so I thought it was a good idea. And the second is that I am terribly French, as you know, and I have a great respect for food, and I think that adding a very heavy formal speech to the usual food was not a good idea. And I thought we could try to have something more, let's say, lighter and less formal than for a solemn speech.
So you reserve this solemn speech for another occasion?
Well, yeah, next year I can make the speech if you want.
Well, congratulations on this great prize. In fact, you are the 33rd recipient, and you join such an illustrious list of great international legal scholars, just to name those who are not anymore with us, like Lord McNair, Charles de Vichel, Susan Burstead, Richard Baxter. Tell us what this prize means to you.
Well, to be very honest, I am not very keen of honors, decorations, in spite of the medals and my robe in The Hague. But honestly, I thought when I was told in October, I think, that I would receive this medal, I thought it was incredible. It was incredible for me for several reasons. One is that, of course, non sum dignus, and I think it is really a great honor. And I'm extremely grateful to the Society, to the Committee of Honors for this honor. But also because, honestly, at least for two other reasons. First, unfortunately, and I deeply regret it, The French are becoming a bit beside the mainstream. We are not present enough among the international law societies, and so how could I be that well known and honored in what we said with Donovan is the biggest gathering of international lawyers of all times, I think, with the addition of the ASIL and the ILA. So this also is a reason. But also, I must say, I think that the Americans definitely are extremely generous. I am probably seen as not the best friend of the USA, and I have this image since 1983 when I was pleading in my first case, which, as Paul reminded in his lovely but too kind remarks, it was pleading against the USA was seen by the most conservative fringe of international American lawyers as being anti-American.
Well, I'm not sure whether this is all the time this way, because I have seen some Americans arguing against U.S. government. I have seen some Australians, like James Crawford, arguing against Australian government in Nauru case. And despite that fact, he is now Australian candidate for the International Law Commission. But I do not remember I would have seen a French international lawyer arguing against France.
And for good reason. Oh, yes, I have. It's not true.
Yeah.
It's not true. Usually you know everything by heart, but on this you are wrong. In the Djibouti case, not Djibouti, but in the Congo case, Congo was represented by three French, one advocate and two professors.
There was a little bit desperate team, frankly speaking.
Well, anyway.
Paul Vergès, you know, he's not a great advocate.
Well, he was seen as a great advocate, but certainly not a great international lawyer. But
Paul Reichler presented you as a great litigator, but this prize is not just for litigators. This is a prize for achievement in scholarship in international law. So I'd like to talk with you about your academic career as well, and not just about your experience in the court, because you are certainly a well-respected scholar, also of a number of great books, number of articles. You are also the one who devoted more than 2 decades to codification of international law in the International Law Commission. So tell us, why have you chosen law as your profession?
Why I have chosen law? Because I was not good in anything else.
And then why professor, academic career?
Well, no. In fact, I was just programmed, supposed to become a civil servant. I was ready to run for the École Nationale d'Administration. And it happened that very young, I was 21, I think, when I was appointed an assistant professor. And my terrible, I don't say I should say mistress, but my terrible tutor was Madame Bastide. And she was a very impressive woman, very...
So you have been a very good pupil. Now you are the recipient. She got this prize a few decades ago.
Yes, and it is probably for me one of the reasons why this prize is special. She got it, and my other master, who was Prosper Veil, they were the only French who got this medal. So it's also for me very, very special to have it. Then I was also appointed a professor when I was extremely young, when I was 27. Then why not international better than something else? And I was not very French on that. I didn't like the pure technicalities. I need to combine technique and legal technique and some imagination, I would say.
You are now the author of the main French. It's not even textbook, it's not treatise on international law.
It's called a treatise.
But originally it was written by Nguyen Quoc Dinh, rather unknown in this environment, I think. Why you have chosen that textbook and not from more famous authors like Charles Rousseau, or Paul Reuter. You opted for Nguyen. His first edition was 800 pages long. Now you have 1,700-page 8th edition.
Well, first, I think what is good in life is just to seize opportunities. It happens that Nguyen Quoc Dinh, who was not really, I have never been his assistant, but it happened that he died 1 year after he published his treatise, which was really the work of his life. And the family tried to find somebody to take over and to write it. They didn't ask me at all. They asked Patrick Daillé, who was his assistant, and they said, I accept to do it, but provided I do it with Allain Pellet. That's all. And I was also very young. It was, I think, in 1978 or something that we took over. So you have no real choice. It was always already a treatise. It was certainly not Oppenheim, but nevertheless, it was a good basis to express.
Well, in terms of length, it's now approaching Oppenheim. And with this medal, perhaps you will also enter this group of les immortels, as you French say. Then, as a young academic, you appeared for the first time before the court. I think your very first case was not the bilateral dispute. That was the first contentious case in Nicaragua versus US. But you appeared for French government in Mortichet advisory opinions proceeding. It was a kind of review of the judgment of the tribunal.
Yeah.
And since then, I think you have established, I would say, a record, 47 cases before the International Court of Justice. You have worked with many counsel. Tell me, who influenced you most in your formative years? Now it's too late.
Well, I am still influential, how do you say, ready to be influenced. So there is no age for that, I think. I had two cases together, contentious. Mortichet was very special. It was advisory opinion, and I just wrote the French memorial. But then I had two together. One was Nicaragua versus the US, and the other was Burkina Mali. And in fact, it's not very nice for my co-counsel, who were Jean-Pierre Cotte and Jiménez de Arrechaga, but in fact, I was the only real counsel in that case. And I had never appeared in the ICJ. I didn't know at all how it worked. But in the other case, there was a vieux routier, an old habitué, who was Ian Brownlee. Brownlee was not very keen in teaching people. He was pop, 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 like that, and he would not try to explain. But he was he had a good sense of the file, and he knew the procedure. So I watched what he was doing in Nicaragua, and I tried to imitate in Burkina Mali. So he was really in this respect, he was a mentor. I felt he was not very easy to go with. We had some big fights in some cases later, but nevertheless, he certainly, in this respect, he influenced me quite a lot.
Well, when you argue, you seem to be convinced. Are you a good actor?
Well, it's up to the audience, so I would ask you the question: am I a good actor? This said, I'm convinced, yes and no. One of your colleagues, René Abrahams, told me it's impossible when you work for a long time on a case not to be convinced yourself. Honestly, I'm not. Quite often, but I think...
So you are just a high professional, yeah?
I am a kind of mercenary, yes. But I would not accept to plead anything. I think there are limits, both intellectual and maybe even more moral limits to what you can plead.
And what were the most challenging cases for you before the ICJ? In the past, not pending cases. We do not discuss pending matters here. But...
Well, so we stopped with the whale case, where I was not successful in persuading you. Fortunately,
Certainly not on jurisdiction.
I
Unanimously rejected.
Do you think I was persuaded? Do you think I was persuaded myself? Well, I will not tell you in any case. But I persuaded the French-speaking judges, the only one who could really see the nuances and subtleties in the case, I think. I will surprise you. I think each case is really a new challenge. You said I had 47. I trust you. I think it's certainly between...
Just in ICJ, there are a few others in ITLOS and arbitrations, state-to-state arbitrations.
Yes, and for me it's not very different. I would think it's more fun to plead elsewhere than in the ICJ now, but it's not. It doesn't make a real difference. Honestly, each case is a new challenge, and sometimes my colleagues tell me, "Oh, but aren't you fatigued? Are you tired with that? Is it?" It's not repetitive. You have a new case. Sometimes, and to be frank, for example, African boundaries, I find that it's a bit repetitive, but every case is a challenge, and I like to fight, I like to win, and when I lose, I lose. It's not...
And what was your major disappointment in terms of the outcome of the case?
Well...
Because you are professional, so you can guess what is the chance to prevail, but sometimes you may perhaps be wrong in your estimate.
I am very pretentious, but I have never been very surprised. Whether I disapprove or I approve, I have disapproved some cases which I won, while I think if I had been a judge, I would have voted against me. I have lost cases which I think I should have won, and clearly it is a case for the whale case on the purely legal ground. But the outcome was not at all different from what I expected. And as I think Paul said very rightly, I am extremely honest with the client. I always tell them, come on, it's impossible. We don't expect anything. And but usually, honestly, I'm not wrong.
Now, moving to another area, you have made a great contribution. You had sat on the International Law Commission for some 22 years. Mm-hmm. What's your experience, and what do you consider as the major outcomes of the work during these 22 years?
Well, that's an embarrassing question.
Since 1990 until 2011.
I have been a member, then it's always difficult to be very negative. Unfortunately, I am. I think the ILC is outdated. I think that it does not answer to the needs of this time. I think that it needs to be reformed in depth. Well, I have last year in this during the colloquium of the American Society, I was also interviewed. I think I have to pass an exam every year during the ASIL Congress. So last year I was also interviewed by 3 young and bright academics, and they asked me a lot of questions on the ILC, so I will not repeat again. But again, my view of the ILC is that it is really outdated, and it should be reformed in depth.
Well, a little bit too critical. When I look at arbitrary awards, how frequently these articles on state responsibility are quoted by arbitrators, well, that's a major result.
It was started in 1930. It was finally in a resolution, annexed to a resolution which personally I approve globally the articles on responsibility, which I think are useful. But if you take the pros and cons, I am not sure that even for responsibilities the balance is good. Again, I don't want to be too much critique, but really the ILC is not my the topic on which I will be the most positive.
And now to another area you have recently become active. You are independent objector. Tell us what's that role to be independent objector in this ICANN, Internet Corporation for Assigned Names and Numbers. Is there an international law element involved?
Absolutely. And for me, this has been a very exciting challenge. Probably it's, except for Internet, among you, the specialist in the law of the Internet, maybe it doesn't speak much. But then for the domain names, the ICANN decided to appoint an independent objector, that is somebody who would be a kind of safety net concerning, to make it simple, in order to make sure that the main public order principles would not be violated. And then I had the role of being the safety net. If nobody opposed to a domain name which could be seen as contrary to the public order, I was supposed to object, and I did.
Recently, a French newspaper wrote an article, and it was not very positive about you. They were quite critical. They are toughest on the media. Why?
On my, oh yes, because it was very positive on me. I don't like media. I think I don't need, I think that lawyers, I have some colleagues, when they see a microphone, they rush, even if it is very far away. I have never spoken to any journalist at the end of a case. I think it's not my job, it's for politicians, it's for the agents, and I try to do my job as a lawyer. So, and it's true, in this article, which I did not authorize, but after all, press is free and they could write whatever they wanted. They said that I am not very nice with the media. And for this, I think for lawyers, whatever many and too many of my colleagues think, I think that media are more often a problem than a solution. I don't think they help. I think that law must be made public, but I don't think that lawyers must have a simplified language for the media. It's not our job.
So you have now been involved in international legal scholarship and practice for some 40 years. What are the major changes, major developments in this area, in your view?
Oh, in international law?
Yeah, international law, international adjudication, have things moved up whether to the good direction or wrong? What's the challenge for the future?
Well,
how international law is effective as the theme of this Congress?
Well, I think...
Is international law, in your view, rather utopia or apology, to use famous Koskaniemi's title?
Well, my view, on this I am extremely optimistic. I think that it is fashionable to say international is in crisis. I suppose it has been in crisis since we have discovered that something like international law existed, and I pay tribute to Grandpa Grotius. But I think it has always been seen as being in crisis. I think this is absurd. I think, just think of the bursting of the individual in the international sphere. This is something tremendously important step forward. Think of the erosion or the disappearance of the so-called reserved domain of states. Now states are always and continuously under the scrutiny of international law. Think of this, there is this proliferation of international judiciary or courts and tribunal. It is criticized in the name of fragmentation. But I think, as has been said by your
my colleague
predecessor, Bedjawi, I think it is really the good fortune of international law. So I think if people that just think where we come from and where we are, the progress have been tremendously important. And I would ask 2 minutes for the but. There is something which is, for me, negative. I think that not a very long time ago, there was a kind of mystique of international law. International law was really, I think of my regretted friend Louis Sohn, for example. Maybe it was utopia, but I think people trusted in international law, that they could accept that there could be progress through law, that there could be peace through law. Now, this all has disappeared. I think that international law is seen more as an efficient recipe in recette de cuisine. It works, but in the name of effectiveness, I'm afraid that we have lost the sense of progress, the sense of this necessity, the sense of necessity of international. It works much better than people think. It is incredibly effective when you see in the context in which it works, but in law we don't trust. And this, I think, is the real challenge for the future generations. I hope that at some point there will be, and when you speak in the worst place in the world for law, which is the Sixth Committee, which is, I don't like the ILC, but I even more dislike the Sixth Committee. It is desperate, it is blah, 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 without any interest, but nobody has a word to say, well, international is something that could accompany progress of humanity. And this, I think, is a black side of a globally very positive trend.
Well, I don't know whether my cross-examination was effective or not, but I'm perhaps maybe helped by audience in re-examination, because I understand there is opportunity also for you to ask questions to Professor Pellet and counsel, an arbitrator, an independent objector, or even a private person. So, please.
My name is Mary Ellen O'Connell from the University of Notre Dame. Thank you very much for the remarks, and I just would love you to say more about your very last point. It's certainly a concern of mine, and I've also seen this negative trend toward what international law could be, what it could do, and for our collective future. But I didn't hear you said you leave it to the next generation to figure that out, but surely you have some ideas about how we could reignite the sense of possibility, sense of a more beautiful future with the aid of international law.
Well, that would be a very vast question, I think, if I really try to answer in depth. But I think in that, well, maybe it's an easy answer, but I think that lawyers are not the one who can change that. I think we can accompany that, but we need an impulse from the political level. I think that as long as the politicians will not relay this message that law is more than pure recipe, that law is something, a tool for progress, a tool for peace, I don't think that that probably lawyers can do much more. But what I also think, and deeply think, is that we should be probably less shy in our relations with the diplomacy, with the politicians as well. I said I don't like media. I don't like to use media for my cases. But when I think that things are important, although I don't like it, honestly, I indulge myself in writing things. I have written rather naughty or bad things on the invasion of Iraq by the United States, which I think was a pure aggression, and it was clearly written. I have written in recently.
So it was in March 2003, yeah, in Le Monde. It was in 2003.
It was 2003
March.
Le Monde, yes. You know everything. You are a very good cross-examiner. You have prepared probably for that. And recently I've written also on the Crimea crisis. Not so much. There was no need to criticize the Russian aggression, but I think there was the commentators mixed everything, and I tried to say separate things. It was not very generous for Russia, indeed, but it was, I thought that you cannot mix the idea of having a referendum and the idea of having things like that. Well, anyway, so I think certainly we have our role in that revival of international law as a tool for progress, but I also think that we cannot do it alone.
Thank you. Any other question? Professor Laurence Boisson-Chazourne, président de la Société européenne. Yeah?
The European Society.
European Society, yeah, but yeah. Yeah, microphone, please.
Like Alain, I'm always very pleased to come to the American Society of International Law, and it's an important gathering for the international lawyers. And we also have a lot of friends in the United States. And I have not had the chance to know well Professor Tom Frank, but I had huge admiration for him. And I remember that Alain also liked him very much. And so maybe we could speak about him. What did you learn from Thomas Frank in terms of scholarship and interpretation and application of international law?
Well, I had planned to speak about Tom Frank, and I gave up because I knew that I would cry. So Tom was one of my best friends. He was, I think he represented what is most wonderful in the US. Peter interrupted me when I tried to say that I was not anti-US, except when I arrive in the immigration and I have to stand up for 1 hour and a half or 2 hours. Then I am absolutely anti-US. But then it is even worse.
In this country, equality under law.
Yeah,
As I arrived without diplomatic visa, I was fingerprinted, despite the fact that I showed them my State Department identification card saying that I cannot be arrested here.
you can.
But nevertheless, I was fingerprinted, so.
So anyway, so at this time, every time I land in the US, I dislike the US, but not for a long time. But then Tom Frank, I think, represented with the best the US can offer. He was generous, he was a free mind, he was keen of, attentive to the post. He was just wonderful, but I didn't want to speak of. I'd given up to speak of him because I knew I would react that way. So I don't. I'm grateful for the question, but I apologize for the answer. Not on Tom Frank.
Professor Brown-Weiss, please.
Alain, my congratulations. And I'm going to hypothesize that we're having this wonderful lunch together in 10 years. Looking forward, what do you see as the two biggest challenges for international law?
Sorry, what is the question?
Looking forward, I'm hypothesizing that we're all gathered together again for this wonderful lunch in 10 years. What do you see as the two biggest challenges for international law looking forward?
Oh, that's a very difficult question. It's not as moving as the previous one. What are the main challenges? I am not, well, I suppose, Edith, that you would like, I say, protection of the environment and improvement of human rights. I can say that if you want. I would say that the challenges are more the eternal ones. How to become more effective is probably the real challenge, and it's more transversal for me than the answer you would expect. I think it's how can we make international effective? How can we make it more generous, more effective to obtain development and peace and protection of the environment? But I'm sure I do disappoint you. But there is a problem with fragmentation. If I had answered, okay, human rights and the environment, I think all is in all, and I think you cannot just isolate. And this is why I've been so critique about the human rightist, what I call human rightism. This idea that you can do with human rights without taking into consideration the whole context. I think that development is as important as human rights, that you cannot separate the issues. This is not a real answer to your question, but it's a way of putting the question my own way. This
Hans Korel. I apologize, Hans. Former Under Secretary, Legal Counsel of the UN.
Thank you very much. First of all, warmest congratulations, Alan. You mentioned during your conversation both Crimea and Iraq. And Iraq. One of my concerns as Legal Counsel of the United Nations, but even more so afterwards, is the United Nations, peace and security, and the role of the Security Council. And it is great sorrow that I've seen permanent members of the Council violating the very law they are set to supervise. I suggested back in 2008 that when you talk about reforming the Security Council, it's very easy to talk about enlargement. I don't think this is going to happen. And I've actually advised against that. I wrote to members of the UN under the title Security Council Reform, Rule of Law more important than additional members. Now, France made a proposal last autumn that the permanent 5 members should adopt a declaration limiting their right to use the veto. And of course, this was my idea also back in 2008. This is the only way I see preserving the Council as an executive organ, but also competent to deal with situations that we see. Everybody is now looking at Syria. So am I, but I'm even more looking around the horizon. Where is the next Syria? Because there will be then one because of the inability of the Council to join hands and really deal with matters when they have to do so. They have to draw a line somewhere and say, if you pass this line, we are forced to come after you, if necessary, by force. Do you have any reflections on that? And in particular, the French proposal, how do you view this? Because I see this as an option for the permanent 5 members to come to an agreement on their own, but also putting a stop to this discussion about enlargement of the Council. I think that should be for the future when a more radical reform could be made within the present number of members of the Council. Thank you.
Excellent question, in particular for one of the main editors of the French commentary on the Charter of the United Nations, now in 3rd edition, 2 volumes, over 2,000 pages. So, Alain, your views about Security Council, how it is meeting the expectations of the world community, what are the challenges in this field?
I think the boss is thinking that I speak too much.
No, by all means. We'll have a question or 2 more, and then we'll let it read.
Okay, well, I think that, okay, I can take your view, Hans, and certainly we need a reform of the Security Council. It can only be made in the long run by changing the charter, but the 5 permanent members have been wise enough from their point of view to make sure that there could not be a reform without their votes. Okay. Honestly, I am not very much interested in these kind of questions. I think it's not pleading for something we know cannot happen is not so much the role of lawyers. And personally, although I think that democracy and the UN are things which are totally different, you cannot say that one vote, one state is democracy. It is a sovereignty, an equal sovereignty, but it is not democracy. And in this, I am very much opposed to many, say, progressive international lawyers who plead for more democracy and then in the UN. And then when you ask them, what is that? Oh, just suppress the Security Council and have one vote, one state. I think this has nothing to do with democracy. But what I think is that there can be made much more of the General Assembly. And the recent resolution on Crimea, I think, was absolutely a good idea. Whether I approve or not the resolution is something else. But I think you can use, on this I am absolutely not French. Don't think that my government would by any means share my views. It certainly would not. But I really think that using the General Assembly more, remembering of resolution Dina Chesson 3775 resolution, using it as an incentive on pressure on the Security Council, on the permanent members, this I think is reasonable and is something which can be done, and I really welcome the step taken by the General Assembly concerning the Crimean crisis. I think this is more fruitful and we have more hope. I have more hope in this direction than in self-restraint by the members. If you ask self-restraint from the French and the Brits, then you have to have self-restraints from the Americans and the Chinese, and I am not sure either of them.
And also fifth member. You have forgotten to mention the fifth permanent member.
So
you have mentioned only 4.
I take the 5 of them, but I think the French and the Brits could be sensitive to the fact that they must have some self-restraints. I don't think that the 2 or 3 others would be. So why plead for things which, from my point of view, are politically unrealistic? While again, the pressure of the General Assembly is not unrealistic. So use it, and I think that it is a good direction.
Mr. President, perhaps one more question?
Yes, over there. Yeah,
Anne Trebilcock.
Thank you. My name is Anne Trebilcock. I'm associated with the Centre de Droit International that Alain founded.
Could you speak more loudly?
Yes.
So that we can hear the question.
My name is Anne Trebilcock. I'm associated with the Centre de Droit International that Allain Pellet founded and former ILO legal advisor. I was wondering if you could talk about a less known aspect of your work, which is your work as a legal advisor for an international organization and your very active participation in the UN Legal Advisors Network. Thank you.
Well, maybe I will disclose. He has an excellent position. Over 24 years, he has been legal counsel for World Trade Organization. And as you know...
But tourism.
Sorry, WTO.
It's WTO.
Yeah, the tourism, yes, certainly. We see it in Madrid, but what's interesting that this organization all the time meets in excellent tourist destinations. So.
Well, when I say I'm the legal advisor for a tourism organization, people say it's fun, but really it's not serious. Well, tourism is the first or the second industry in the world, so it's not as rubbish as that. But it is a very small organization. We are less than 100 staff members. I am not in fact, I do it virtually pro bono, but it's fun, it's exciting.
Not completely pro bono.
Not completely. Well, I can. You want to see my tax declaration, or nearly so. But for a professor, and my first job is to be a professor, honestly. If I am asked, what do you do in life? I would say, I am a professor. But for a professor, being a legal advisor, and for a long time I was not only the legal advisor of the World Tourism Organization, which is a specialized agency of the UN, and I was the man who made it possible, legally speaking. It was quite a hard job. And seeing the life of the organization from inside, because I am seen as a member of the staff when I am there, having meetings with, since Anne is a former legal advisor of the ILO, participating in the meetings of the legal advisors, which is, and Hans will not say the country, which is a small world. They know each other very well. And for a professor, being really part of this game is wonderful. And this changed I think, my way of teaching and my way, at least, of thinking about the international organizations. Since it might have been the last question, I understand, I would like to thank all of you, of course, who have come to listen to my not very interesting answers, I'm afraid. To thank very much Peter Tomka, who accepted very graciously to do the interview.
With some hesitation, because I had the feeling that certainly I do not have the qualifications of Piers Morgan. And as you know, he's on his way out. So I hope that this does not indicate that I am also on my way out from the institution.
Sounds like Peter's thinking about his next career. And thinking
but I want also to thank the American Society and President Donovan and President-elect Laurie Damrosch, whom I congratulate heartily. And I want to thank Foley Hoag for their incredible generosity, because you might have thought that we have worked together for years, but usually we work against each other. So I am certainly the best enemy of Foley Hoag, and I think it was very kind of them to sponsor this.
Well,
so thank you, everybody.
Thank you to Paul and Foley Hoag for supporting this. President Tomka, Professor Pellet, thank you for that wonderful discussion, which should prompt us all to realize that we have only one more day to consider. We have till midday tomorrow to consider how we're going to tackle a lot of the problems that we've just discussed. But there are lots of panels to do that. So I welcome you all to resume at those panels. I also want to remind that I think we have a few tickets for the gala tonight at which we will formally present the medal. But there are a lot of things else happening at the gala, including a keynote address by Donald O'Turk. So if anybody is inclined to go, I think we still have room. But again, Peter, Alain, Paul, all, thanks for a great discussion.
Thank you.
Bon. T'as sauté pendant le